Is it?
All right, good morning, everyone. Matt Braden here from GPAR. Hope everybody has gotten their day off to a good start. Before we get into today's workshop, just a couple of quick housekeeping things. Friday morning, we're gonna have our buyer agency contract workshop hosted by Trent Pettis. Hope you can join us for that. Trent is one of our great presenters, so that's a great opportunity to go ahead and, again, build up your tool belt to better serve your folks and to increase your professionalism. So hopefully we'll see you guys there. And then code of ethics. Many of our members have taken care of their code of ethics requirement. We have a reporting deadline at the end of this year. Remember, the code of ethics is the foundation of everything that we do. And every 3 years, you have to go ahead and fulfill your code of ethics training requirement. At the end of this year, that requirement is due. So if we have sent you a message, we encourage you, we implore you, let's take care of business now. Let's get it done with. We will be having a virtual class next week, Wednesday, hosted by Heather Patron-Shook. It's a great way to go ahead and get it done. Heather is an engaging presenter, and she will answer your questions, keep it moving, and it's probably the best way to go ahead and take care of that requirement. There are other ways to do it. Another one is via the NAR website, in which you're able to do it online. And once you start that course, you have 30 days to complete that. So it doesn't matter to us how you do it. We just want you to do it. If you've done it via continuing education, you need to get that certificate of completion into Donna LaPera from our team. She's the gatekeeper on code of ethics for us. And the last thing we want to have happen is her knocking on your door in January. So let's make Donna happy in July, right? We like a happy Donna. So with that, we're going to get into our workshop today. We're very fortunate to have Jénel and Paul join us. They are legal eagles. They're experts on things that relate to rental properties. We're very fortunate that we get to work very closely with Paul, in particular with the Real Estate Coalition, which is comprised of real estate influencers and organizations that have a vested interest in what goes on in the Philadelphia real estate marketplace. So Paul's been a great resource to us over the years, and we're glad to have Paul and Jénel with us. So with that, the floor is over to you, Paul and Jénel. Welcome. Good morning.
Good morning.
Awesome. Good morning. Just a real quick disclaimer. Things in Philadelphia change very rapidly these days, ever since COVID and last March. Jénel and I have been doing a ton of seminars, and we get done these seminars and the day later, everything's changed. So we try and tell everybody, especially since this is being recorded, if you're listening to the recording, be aware that this may be outdated by the time you're listening to it. And for those of you that are on this call, be aware that this may be outdated after this call is over. So we're going to give you the current information as of this moment, but it doesn't mean that it's going to be good after this moment. The other thing I would do
at this moment, we did this one time at 10 a.m. and then everything changed at about 1 p.m. and we just sat there shaking our heads. So, I mean, it's literally this moment. It could change in 3 hours.
The other thing I do want to say is that as we go through this, Jénel and I are members of a lot of different organizations, actually member of GPAR as well. I am a real estate broker. Jénel is a real estate salesperson. We're also members of a lot of different other organizations like the Apartment Association, National Apartment Association, Pendalama. I go on and on. The reason I'm mentioning that is because as we go through this, we'll sometimes I'll say I. When I say I mean we. So it's Jénel and I, and it could be different organizations. It could be Matt that's involved in a lot of the stuff that we do as well. And when I say we, it could be we could be any one of those organizations. It's just really hard as I go through this to distinguish which particular we or I am talking about. So just know that when I say that, it could relate to any one of those organizations. All right, let's get started. There's a lot of stuff that's happening in Philadelphia. Unfortunately, we're not going to be able to get through everything today. This is just an hour. We're going to try and touch on a lot of the pertinent stuff that's going on for all the things that we're going to be talking about. So, you know, Jénel and I have probably done an hour to an hour and a half seminar on each one of these topics. So as you can imagine, it's going to be very hard to get into the weeds on a lot of this stuff. But what we want to do is make sure that you're aware of the different things that are out there so that you can go in and investigate and figure out what they are later on your own. And if you want to, like we have on our website has a lot of our seminars that we've done. You can go in and look at those seminars to get more details on any particular topic. The first thing I want to talk about is the broker laws in Pennsylvania with regard to rental properties. So people are very confused with what you're required as a property management company in regard to signing leases, renting out property, things of that nature. So if you own a property management company as a real estate company, that's great. You'll represent different owners. So you have an owner that comes to you and says, hey, Matt, I want you to represent us and manage our property. It's very important that when that management company goes and signs a lease agreement, that lease agreement is signed by the broker of record of the management company. The real estate agent cannot sign that lease agreement. Extremely important. And even more so, don't have the property manager, who may not be a licensed real estate agent at all, sign it, or a secretary or somebody else that they say is the agent for the owner. Absolutely not. Either the broker signs the lease agreement or the owner signs the lease agreement. If possible, it's great if you can get that lease agreement over to the owner and get their approval and let them sign it. But if not, the broker of record has to sign the lease agreement. Do not, can't say this emphatically enough, let the real estate salesperson sign the lease agreement. That is not valid. It's going to get you in trouble. Okay. And if you do get in trouble, the real estate commission comes in, they will subpoena every single lease agreement that was signed. And every one of those carries a $1,000 fine. So be real careful with regard to that. All right. The other thing I want to mention is that Philadelphia passed what is known as the good cause eviction law. Basically says that you need to have good cause before you can evict a tenant or terminate a lease, basically. It's similar to the laws in New Jersey, but here's the key. It only applies to leases that are less than 1 year. So if you enter into a month-to-month lease, you basically cannot terminate that lease unless you have good cause. That month-to-month lease becomes a lease basically forever, unless of course the tenant does something to breach the lease agreement. But if you just want to end the lease agreement, you cannot. So what we recommend to everybody is that you sign leases for at least 1 year. You should not have any lease agreement that's less than 1 year, because what that does is it allows the tenant to stay forever if they want to. But on the other hand, if they want to terminate the lease, they can get out of the lease at any point in time. But you can't end that lease agreement. That's a problem. So in Philadelphia, make sure that all your leases are for at least 1 year.
And make sure that any renewal, automatic renewal you have on those leases are also for a year. We're not 100% sure how the courts are going to interpret that. So if it's a 1 year lease and then it auto renews on a month-to-month basis, once you hit that month-to-month basis, they may then call that a short-term lease. We were hoping to get a little bit of some interpretation from the courts in Philly, and then the pandemic hit, and we really didn't have many cases going forward so that for us to look at that. And now they're just not hyper-focused on it because of everything that's going on. So just precautionarily make sure that your renewal periods are also for 1 year.
If I could just jump in for a moment, a little background to our GPAR folks. Paul was very influential during that entire process in which that legislation was proposed, as well as GPAR and some of our other friends. And while the outcome wasn't exactly what we would have hoped for, when we look at what the legislation was when it was originally introduced, it was far, far more harmful than what it actually wound up residing on. So kudos to Paul and all the efforts that he went in to partnering with us, as well as being strong advocates for property owners during that process.
Before we move on from this, Matt, there's questions in the chat. I usually just monitor it. Do you want to keep doing it that way? Is that okay? Or, okay. So Paul, it's saying, what about current leases that already have a month-to-month renewal? And then someone said, a lot of tenants after the first year specifically request to go month-to-month since they don't want to buy, or they may want to buy. So you recommending we say no. So how do you handle those two situations?
Okay, so on any one that you have month to month now, when that month ends, or when it's renewing month to month, you should change that to a 1-year lease.
Right.
As far as a tenant that wants to go month to month because they want to buy a property and what have you, what I recommend there is you enter into a 1-year lease, but you give the tenant the option to be able to get out of the lease. If they buy a property, you can put whatever other conditions that the tenant wants in there, as long as you agree to them, obviously. But that's the way you would handle that. But you still want to have it as a 1-year lease. You do not want to have it as a month-to-month lease.
And is legally raising the rent at renewal time a valid strategy to create an incentive for the tenants to choose non-renewal?
So, yeah. So basically, you can raise the rent, but to get rid of the tenant, so to speak. But the problem you have there is that when you rent that property to the next tenant, you have to rent it at that higher rental amount. If you go to rent it to the next tenant and you rent it at a lower amount, then you're in trouble. So if you want to raise the rent, that's fine, but you can't do it just to evict the tenant. If you raise the rent, you're going to have to charge.
And it's going to need to be reasonable and tied to market rent, because if they can prove you're doing it to circumvent the law, you're in trouble there too. So whether you rent it to the next tenant or not at that higher rate, even if you don't rent it out right away, let's say you do something else with the property, if they can prove you're doing it just to circumvent the law, that's not going to fly.
Yeah, so the shorter answer is no.
Yeah, don't do that. Unless it's a reasonable rate increase and the tenant just can't handle that. Okay, that's it.
All right. Next one to quickly talk about rental assistance. This is the big thing now that if you have.
Before you do that, do you want to talk about what's going on with evictions that leads into rental assistance? I mean, you don't have to, but I feel like then we're going to backtrack.
Sure. I wasn't really going to get into too much of the evictions in this call because that's a 2-hour conversation.
Yeah, I just meant a 5-minute overview.
But we can just touch on it quickly.
Yeah.
So basically what's happening with evictions is there's still the Cdc moratorium on evictions. The problem with the eviction law, and explaining it now in this 1-hour seminar, is that it keeps changing constantly, and whatever moratoriums there are that are out there are going to end, or they're going to be renewed, or there's going to be a new one. So we really don't know what's going to happen with regard to that. The current state is that the CDC has extended the eviction moratorium federally through the end of July. That only stops you from being able to actually lock out the tenant. It doesn't stop you from being able to file the eviction and go to court. Separately, the city has all these laws, which I'm not going to get into, which prevents you from just filing an eviction complaint without going through a lot of hoops and hollers.
Well, okay. You can't file an eviction complaint right now if you do not apply for rental assistance. That's kind of where I was leading with that before you got to rental assistance. So your hands are tied. Not only is rental assistance going to be beneficial to you, and Paul's going to explain all the reasons why, you don't have a choice. You can't put tenants out right now until you have you yourself apply on their behalf for rental assistance. That was kind of what I was getting to. Sorry, probably should have said
Thank
that.
Okay,
Okay.
so if you haven't already, if you have a tenant that's not paying you, suggest that you immediately apply for rental assistance to get the money that's available to pay for the rent. Here's the problem with the current rental assistance. Under phase 4, which is what we're in now for rental assistance, there is approximately $127 million that has been appropriated to the city of Philadelphia. It's done through 3 different tranches of money that the city has available to it. Of that $127 million, $41 million has already been given out to approximately 5,600 tenants. There's been over 36,000 applications for rental assistance. You don't need to know these numbers, but the reason I'm explaining them to you is so that you understand that approximately 1/7 of the applications have been approved and the money has been given out, but the money that's been given out is 1/3 of the money. So if you follow that to its logical conclusion, the city is going to use up the $127 million on approximately half of the applications, which is why it's extremely important to get your applications in immediately, make sure they're accurate so that they get approved, because if you don't, you're likely not to be able to get paid under the rental assistance. And in rental assistance, this new phase 4 is a great program, pays for all the rent pretty much, covers approximately 15 months, possibly 18 months of rental assistance, of unpaid rent, and it covers the back rent from April of last year.
We have a question here. Can landlords that have a lapsed rental license apply for rental assistance?
No.
No, unfortunately, you have to upload your rental license.
And that's a great question, because it leads into the issue of, if you don't have a valid rental license, you can't collect the rent at all. The rent's not owed. So not only aren't you able to get the rental assistance, the tenant doesn't have to pay you. That's a problem. So make sure, number one, get that rental assistance, like that, the rental license, so that you get rental assistance. Very, very, very important. Okay. And for those of you that aren't collecting the rent because tenant's not paying, get that rental assistance application in immediately. All right. Any questions on rental assistance?
How I said before, you can't file an eviction until you apply for rental assistance. The clock starts ticking when you put the rental assistance application in. So you need to get, like Paul said, that's the second reason you need to get that in immediately, because it's 45 days you have to wait. So that clock doesn't start until you put that rental app in for rental assistance. Another question, a couple questions. Is there a standard percentage for rent increase? Oh, I think we're back on the other topic. No, there's not a percentage. It has to be tied to market rent. What happens when a tenant...
And it has to be reasonable.
Right. What happens when a tenant who received rental assistance from a previous phase but did not pay the money to the landlord? Okay, so this phase goes directly to the landlord. That's what's so great and so different about this phase 4 rental assistance. If you put the application in, you do what you're supposed to do on your end. Once the tenant does what they're supposed to do on their end, the money goes directly to you. It does not go to the tenant. So that's why you want to get your application in immediately on this phase. On a prior phase, if they're going to deny them because they got money already for that phase and didn't pay you, that would be a reason that you could then take that denial and move forward with the eviction.
Yeah, that's actually a great question, because the tenant is legally obligated to give you the money.
Mm-hmm.
And under phase 4, what happens is that if the tenant applies on their own, you have 20 days to approve that application. If you don't approve that application, then the tenant can get the money directly. And then the tenant will be obligated to pay you, similar to they were obligated to pay you under the other phases. It's criminal for them not to pay you. So you should be going after them, and there's really no mechanism yet, or clear cut mechanism for going after the tenant. And quite frankly, I haven't seen one case yet that was filed against the tenant that didn't turn over the money. I'm waiting for that. But I would definitely go after that tenant to get the money. That's theft. That's your money that they've stolen, that was given to them from the government. So
At a minimum, you'll be able to evict them for keeping it, not giving to you. Okay, lots of other questions. Where do you find the rental assistant application? Can it be submitted online? It's all online. Yes, just Google Phase 4 rental assistance Philadelphia, it'll pop right up. If a landlord has an active rental license and has applied for rental assistance, but it was denied, say because they run out of money, can the landlord then proceed with the eviction filings? We don't know yet. I mean, we assume so. They haven't run out of money yet. As Paul said, they've only gone through about a third of it. So as of right now, the process is you apply. If it gets denied for whatever reason, let's say it gets denied because the tenant, doesn't meet the poverty level, the income level, or that, the tenant got prior assistance, or whatever the reason is, you can then take that denial letter, turn around and use it when you file for the eviction. You don't have to wait the 45 days once it's denied. We believe we kind of haven't been running into this. I think we've only received a couple of denials. And in those cases, the tenant actually paid. So we haven't had to throw one up yet in front of the judge, but that's what we believe can happen. All right.
So what's happening in New Jersey, which is very interesting, is that the back money that was owed during the COVID-19 financial hardship period is considered a civil debt. And it's a debt where you cannot go ahead and evict the tenant for non-payment of that civil debt. That's not the law in Philadelphia, but I'm sure the legislators in Philadelphia have seen what they've done in New Jersey. And legislators in Philadelphia generally don't come up with their own ideas. They generally follow what's done in other cities and states. So I'm guessing they're looking at what's being done in New Jersey, and don't be surprised if there isn't a bill that's introduced in Philadelphia that's going to say the same thing. With the idea being that now that the rental assistance isn't available, that tenant in theory should have gotten, somebody else got it. Why should that tenant be evicted as opposed to the other tenant? And then they'll just say, okay, we're going to make that a civil debt. I don't want to give them any ideas, but that's generally the way things happen. And as Matt will tell you, what happens in City Hall, whenever there's an idea that's floated out there, the first thing they will say to us is, what are they doing in other cities? What are they doing in other states? What else is happening around the country? That's how Philadelphia operates. And quite frankly, that's how the state of Pennsylvania operates as well. We're not cutting edge here in Philadelphia or Pennsylvania. It's not like Florida, California, Texas, places like that. Pennsylvania, I might try and tell people that basically after 26 states get on board with something, Pennsylvania gets on board with it. So will marijuana be legal in Pennsylvania? Sure. I think it's legal in
Jersey starting 2022.
12 states, 18 states, something like that. But anyway, it's not up to 27. So we got a couple more to go, and then Pennsylvania will legalize it as well.
Okay, so a few more questions.
Yes.
If you approve the application, are you unable to evict within a certain time frame? Yes. So once you start receiving your payments, you cannot file the eviction for 90 days after you receive the last payment. So, but you don't have a choice. You can't not take the money because you can't evict if you don't apply. So it's not like you can just say, okay, never mind. But you should, in theory, if they are approved, get all of the money that is due and owing up through that application and possibly some future rent. So at that point, you should be made whole, and then it would just be for future rents. And at that point, you could file after 90 days.
Yeah, what's interesting is the law says 90 days after the last payment. And the question becomes, if your last payment was, let's say, in July the 1st, would you be able to file 3 months after July 1st or 3 months after the time period that the money is applied to? So in other words, if you got paid on July 1st, it was for July's rent, then in theory, you might not be able to file until 90 days after August the 1st. We're being told that that's pretty much the interpretation that it's being given, but that's not a legal interpretation. That's going to ultimately have to go to the courts to decide that. But to be safe, I would say it's 90 days after the end of the period that's covered by the rental assistance.
Okay. Oh, Matt put the link in there for everybody for the rental assistance, so that's awesome. Okay. One of the tenants received $9,000, did not give to the landlord, moved out. Time came, assistance came to an end. Yeah, I mean, there's not much you can do. Send it to collections. It's horrible, but. And what is the process of removing squatters? So this all applies to non-payment of rent cases. If you have some type of a breach of the lease conditions or some other type of thing going on, you can still file in Philadelphia. As Paul said, right now, there's a moratorium on the lockouts through the end of the month if they have some type of a CDC declaration. That is not supposed to apply in non-payment of rent cases. We have found that the judges are having it apply anyway, out of an abundance of caution. We believe that is going to expire at the end of this month. We're not hearing rumblings yet that it's going to be extended again. So at this point, you can go ahead and file for other reasons other than non-payment of rent. By the time you get through that process, you should be able to do the lockouts. We hope.
And squatters is a topic for a whole other seminar. It's very complicated. What's crazy is that squatters actually have more rights than tenants.
Right.
As crazy as that might sound, you would think that somebody that's squatting on your property would have less rights, but they actually have more, because the argument with regard to a squatter is that they actually have some type of ownership interest. At least that's what they're claiming to the property. And it's much more difficult to get a squatter out of your property, or at least it was. There was a bill that was passed in Philadelphia a couple of years ago that helped the situation tremendously. And what's happening is there's now guidance that was given to the police department on how to handle squatters. So if you are dealing with a squatter issue, you need to address it immediately, because if you wait more than 30 days, it becomes a problem. So if you have a squatter in your property, you need to call the police right away, get them to come out. And then there's a whole process, which I don't have time to explain right now, but there's a process that they will go through. If they determine that, in fact, there's probable cause to believe that they are a squatter, they'll go ahead and remove the person from the property. So the short answer to your question is, if you have a squatter, act quickly, call the police, and try to get them out.
We're getting a lot of questions that people are asking, that if their tenants got phase 3 and never paid landlord and now they're refusing to leave, what are we supposed to do? Again, and now this person's saying they applied for phase 4. My guess is they're going to get denied for phase 4. Once they get that denial, you get that denial letter, then you can go ahead and then do the eviction. All right.
Or maybe not, Jénel, because if they've gotten phase 3, it doesn't prohibit you from getting phase 4. Let them apply for phase 4 too. At least you'll get the phase 4 money. And then when that starts happening, you should get assigned a counselor, and then hopefully at some point in time, they'll realize that you didn't get that other money, and you'll be able to work it all out with those people.
Yeah. I don't know if they have a record of who got what, phase 1, 2, 3. And if they do, if they're using that as a reason to deny phase 4, I have no idea.
They do cross-reference those. They wouldn't know that the tenant didn't pay you directly. See, they would be able to apply for the phase 4 rental assistance. And what I would do in that case is apply for diversion and get a housing counselor involved through the diversionary program. And hopefully you'll be able to get your money that way. And they'll help you.
That are the end of the questions in the chat.
Awesome. All right, moving on. I want to talk about the Fair Practices Ordinance that was recently passed by City Council. It's Councilwoman Kendra Brooks' bill. Has not been signed by the mayor yet. I don't know what he's waiting for. I'm assuming he's going to sign it. He's indicated that he was going to sign it. So I'm sure it will get signed shortly. But as of now, it's not a law yet. but I'm sure it will become a law, reasonably certain it will become a law. So I want to let you know what that's all about, so that you can start preparing for it. Under this law, you now have to have uniform rental screening criteria that you give to the tenant prior to them renting the property. So you have to come up with that uniform screening criteria. If you have a website, it needs to go on your website. If you have a property where you can post it, like you have a multi-unit building, it should be posted at the property. And at a minimum, it should be given to the tenant when they apply for the apartment. Very, very, very important that you have that written rental screening criteria. Okay. Now, this is my favorite part of this. You then have to do an individualized assessment of each tenant based on the uniform screening criteria. And if you're confused about that, you're not the only one. The question is, how can you do an individual assessment on uniform criteria? If it's uniform criteria, they should qualify, not qualify. It should be nice and simple, but it's not so simple. So the best explanation I can give of this is that you basically have to make rules, but all the rules have exceptions to the rules. So what are those exceptions? Depends on the individual case. You have to make an individual assessment to determine whether or not that individual falls into some nebulous exception that you have to look at. Craziest law I've ever seen, but this is Philadelphia, and this is what we have. So you basically, like I said, have to make an individual assessment based on uniform criteria.
So here's a good question with regard to that. First, before that, someone asked, what is diversion? I don't know if you want to backtrack to that or just deal with that at the end.
Yeah, diversion is just a fancy word for mediation. So I don't know why they didn't call it mediation, but they want to use the word diversion. I guess they're diverting you from being able to file an eviction case. You're being diverted to this other program. It's basically mediation. Not basically, it is mediation. So prior to being able to file for an eviction case in Philadelphia, you first have to file for diversion or mediation. That's what diversion is. So my recommendation to you is if you have that situation where the tenant's taking the money, then you would basically want to go ahead and try to evict the tenant because they haven't paid the rent. But before you can do the eviction, you would have to file for diversion. And that's what I was saying before, is file for that diversion or mediation. And when you do that, a housing counselor will get appointed. You'll apply for the phase 4 rental assistance at the same time. And then hopefully through that process, you'll be able to work out being able to get paid.
Okay, now back to the rental screening criteria. So consistent rental screening criteria makes sense for apartment buildings or for a landlord, but what about a management company who represents various different landlords and the landlords each want different criteria? It's a very good point.
Yeah, so you would have to have uniform criteria for each separate owner, which is fine. You can do that, but you want to make sure that you have written criteria that's given to that tenant before they apply.
You can just hand it to them with the application so that they see it. Just make sure you're giving them the right one for the right owner.
Yeah, and it's not a problem whatsoever to have different criteria for different owner. That's perfectly okay. It doesn't have to be uniform across your property management company. It can be separate for each owner. That's perfectly all right.
Great. And then if the criteria is listed on your online application, is that good enough?
So great question. Nobody really knows what's going to be required here. And just to go back a little bit, when a law is passed, you have legislators passing the law. Oftentimes they're not attorneys. They're certainly not judges, and we have different branches of government. It's now up to the courts to interpret what those laws are. So the law is written, legislators may intend it to say certain things, but until it goes to court and the court interprets what it actually means, We don't know. So until a court actually interprets what the law says, we're not going to know the specific answer to that question.
For me, I mean, based on what the law says now, it sounds like it should be okay as long as it's very clear in your online application. And, you know, that it's given to that tenant. What's nice about that is it's like, that is uniform. It's uniform across the board for everyone that's applying for you, and they see it. So I like that it checks all those boxes.
Yeah, it's definitely good. If you have a website, I would absolutely make sure that it's on your website.
Right.
If you don't have a website, you don't have a building, and all you have is the ability to give them the document at the application, then presumably that will be okay.
All right, that's it for questions.
All right. So as part of this law, you cannot, as part of your policy, state that you have a blanket exclusion for either prior evictions or based on the person's credit score. Doesn't mean you can't consider those things, but you can't have a blanket exclusion that says we will not accept anybody that was previously evicted. You can't have a blanket exclusion that says we will absolutely exclude everyone that has a credit score under a certain number. Not to say that you can exclude them, but your uniform policy cannot say as a blanket rule that you won't exclude, that you will not accept them. So you basically have uniform criteria that says this is the credit score that you need. However, you still have to do the individual assessment to see if there's extenuating circumstances as to why you would take that particular tenant. The blanket exclusions gets you in trouble every single time, not just for this,
Criminal.
but for criminal stuff, fair housing laws, like that's the problem. Anytime you have a policy that says we have a blanket exclusion we will not accept, and you fill in the blank, you will get sued every time for under fair housing laws because you're discriminating against people for some reason with that blanket exclusion. Okay, so eliminate all of your blanket exclusions. Not good.
We've been told you cannot collect the last month's rent. We now collect 2 months security. I see other companies calling it last month's rent. Is this legal? Oh, that's not pertaining to this, but we can answer that, I guess.
Yeah. So the law in Pennsylvania is that during the first year of a lease agreement, you can have 2 months in security. After the first year, you can only have 1 month in security. You can increase the security deposit up to the amount of the rent every year, up to the first 5 years. After 5 years, you can no longer keep increasing the security deposit. Okay. So just real quick, first year, you can have 2 months in security. You can call the security deposit whatever you want. You can call it last month's rent. You can call whatever. It's going to be considered security deposit. And that's the Supreme Court of Pennsylvania came out with a decision recently. It's not so recent anymore, but where they clarified that the last month's rent in advance is a security deposit. So if you take the first month's rent and the last month's rent in advance up front, at the end of the year, you absolutely have to give them back that last month's rent in advance.
Correct.
Because after the 1 year, you can only have 1 month in security. Okay, so the easiest thing to do is just take 1 month in security, and makes it very simple. I can tell you there's a lot of landlords that are out there that take the 2 months or the first and the last, and they don't give it back after the first year, and they have gotten into trouble for doing that. So if you are taking the 2 months, whether it be 2 months up front or 1 month plus the last month in advance, make sure at the end of the year you give that 1 month back, so that you're only holding 1 month after the first year.
Okay. Are all landlords in Philadelphia required to accept home choice vouchers now? Home choice voucher? You mean like Section 8 vouchers?
Yeah, the housing choice voucher. That's another topic for another day, another 1 hour seminar on source of income and whether or not that's a protected class in Philadelphia. The short answer is that Philadelphia does have a source of income law. The law is basically says that you cannot discriminate against someone based on source of income. Section 8 housing vouchers fall into that source of income umbrella. So that in theory, you shouldn't be able to exclude somebody that has a housing choice voucher. There's a lot of exceptions to that, which I won't get into. Don't have time.
Is a pet deposit considered a security deposit? No, not necessarily. The pet deposit needs to be reasonable. That can be separate, but understand that if you take a pet deposit, you are limited to that deposit. So if you take $250 in the pet deposit and the pet destroys the house and causes $1,000 in damage, you're limited to the $250. The courts have been upholding. So we just recommend that you don't do it.
Yeah, it's when you're taking that money, it's basically considered as liquidated damages.
Right. Okay, last question is the same as the one before about last month's rent. So, okay, that's it on questions. Next.
Okay, just to finish up with the fair practices ordinance, there are certain things that you can't, certain things that a tenant has done or hasn't done that you can't use to exclude the tenant from renting the apartment from you. So these are things that you absolutely can't consider at all. So as mentioned before, you can't have blanket exclusions for prior evictions or the credit score. And now these are the items that you cannot use as a basis to exclude a tenant. So for instance, if there was a non-payment during the COVID-19 financial hardship period, which ran from March of 2020 through the end of December 2020. So if there was a non-payment of rent during that period of time, you can't use that against the tenant and deny them an apartment based on that. If there was an eviction that took place, or was filed, I should say, but there was no judgment entered against the tenant, you cannot consider that as a negative and not rent to the person just because they were filed against. It's kind of the same concept of innocent until proven guilty on the criminal level. Just because someone was charged with a crime doesn't mean they were guilty. Just because someone was filed against doesn't mean that they did something wrong if there was no actual judgment entered against them. So the filing against someone is not something that you can consider anymore. If the tenant's record was sealed, which they don't have a sealing bill, but that's coming. This is being done for future reference. So if their record ever gets sealed, you can't consider that. If they did have a judgment, and this is one of the things that really bothers me, if they did have a judgment that was entered against them, and that judgment is vacated or satisfied, you can no longer consider that judgment. So if the tenant was had an eviction filing against them, they got evicted, but then they paid that judgment, you can no longer consider that as a negative against them. Quite frankly, I think that's ridiculous, because there's lots of reasons they may have paid it. The point of the matter is that they actually were, I don't want to say guilty, they were negligent, they were, give me that word, they were wrong.
Money. Yeah, they owed the money.
They owed the money. The judgment was entered against them. It's like, come on, because that's the equivalent of, okay, the person was found guilty on a criminal case.
They breached the lease, you know?
They're found guilty, but okay, maybe they paid whatever, there was a fine, but they were still guilty. Okay, same thing here. That should be something that you should be able to consider. Unfortunately, under this law, you cannot. If there was an eviction that was filed against them more than 4 years ago, you can't consider that.
That one doesn't bother me as much. Because people, you know.
And the final thing is, if there was a judgment by agreement that's currently in place, you can't consider that either. So they went to court, they realized they were wrong, they entered a judgment by agreement, they said we're going to pay X amount of dollars per month. If they're paying under that and are still in compliance with that judgment by agreement, you can't consider that either. Another one of those I have a problem with, but there you have it.
So if I could jump in for a moment, Jénel.
Yeah, jump away.
So this isn't going into specific legislation, but this is really about the overall activism by city council at this moment as it relates to the rental space. What is this attributed to? Why does it seem like there is just this constant flow of these types of bills that are trying to go ahead and be more restrictive as it relates to a property owner and their rights? And then second part of that, Paul can probably speak very well to this. What can our members do when this stuff starts to come down the pike, when we're trying to get their attention to let city council know about our opinion or voice on an issue as it relates to the bills?
The answer to your first question is that we have a one-party rule in Philadelphia. You basically have one party that is dictating all the different laws that are getting passed. I try and explain to people that the best form of government is where you have divided government. You don't want it to be too far to one side or the other side. So you want to have both parties represented, and basically you want to have bipartisan bills. And what should really be happening in the way, not to get too technical with this, the way our laws were intended to be written, where is a new laws shouldn't just be coming about every single week. Okay, if there's a problem that needs to be addressed, then that's what you have legislators for. They should debate it. It should be discussed. It should be weighed on both sides, and then a good solution should be brought forward. Not this constant, hey, let's just keep changing things. Let's just keep changing. So the Democrats get in power, and then they want to change things to make everything more liberal. The Republicans get in power. They want to change everything to be more conservative. No, it should just, everything should stay status quo. And then when there's a problem, that's when the legislators should step in. We're in a climate right now where it's very liberal with what's happening, as you all know, and city council is moving in that direction. It's being pulled in a more liberal direction. It's already liberal. It's all Democrats, or mostly Democrats, majority. And now it's moving in a more liberal direction from there. So that's pretty much what's happening. So next thing you're going to see coming out is rent control. You know, we've been fighting that for years, been holding it off, but I hate to say it, but probably by the end of the year, my prediction is you're going to see a rent control bill be introduced. Hopefully that won't get passed.
It's amazing to me that we're getting rid of it everywhere else. You know, Jersey's phasing it out, and we're going to introduce it. They've proven it doesn't work.
Yeah, cities and states realize it's a bad policy that have it. They're all doing away with it, and now we're going to end up having it. But that's a topic for another discussion. In answer to your other question is, we need you to get involved, and involved in a big way, and talking to your legislators, city council people, especially where you live, your council person in your district, if you have properties in that district, let them know that you care, get involved, show up at city council when these things are getting discussed. The more you get involved, write letters to them. And I'm sure that, I guess, let's see if Melody's on this call. But yeah, you guys send out emails, flyers all the time to get involved. The more you get involved, the better off we are.
So message to our membership, when we put out a call for action, which we're not doing that every single day, you know, it's very judicious and it's strategic. But when we do that, we need for our folks to go ahead and respond in a big way. So thank you, Paul, for answering those questions.
Yeah, no problem. I did want to real quick talk about bed bugs and lead paint. I don't have a lot of time, so I'm just going to touch on them, but want to make sure you're aware of what the new laws are with regard to it. Bed bugs. You are required to disclose the prior history of bed bugs over the last 4 months. You should have the tenant sign a bed bug addendum. And you also have to give them the bed bug brochure that the city of Philadelphia has given out. If you're not familiar with that, make sure you go on the city's website and become familiar with it, because it's very important that you comply with those laws. The other main issue is lead paint. Under the new lead paint law, every single rental unit in the city of Philadelphia needs to be tested. Under the old law, You only had to test the unit if you had a child 6 or under that was going to reside in the property. Under the new law, every single unit needs to be tested. The new law is being phased in over a period of time, depending on your zip code. You can go online and see when your zip code pops up for compliance. A lot of those zip codes have already popped up and you need to be in compliance. Extremely, extremely important that you have that lead paint test done. If you don't have that done, not only can't you collect the rent, but the rent that the tenant has already paid you can now be, well, now the tenant can ask that that money be refunded to them.
And a lot of them have been already phased in. It started in October. That was one set of zip codes. And then April was another set. So about half the zip codes have been phased in already. Another set will come out this October. And then finally April, right?
Yes.
Or was it October? Yeah, April. So
Yes.
about half of them have phased in. Matt just put in the link for people. No. Matt just put in half codes link. Is there, Matt, is that a link with regard to the zip code?
No, there was a question about an
Oh.
association that focuses on rental properties.
Oh,
specifically.
right. I see that now. Okay, sorry. Anyway, it's on the city's website so that you can go look at that. People are asking whether it has to do with new construction. It's all rental units. Once you are determined as lead free, not lead safe, then you're done. You only have to do it once.
So so any property that was built after March of 1978, in theory, it doesn't apply to. I say in theory only because you still have to disclose whether or not you know about the existence of lead in the pipes. So you still want to have them sign an addendum, and you still have to let the city know that it's new construction and that the property is lead free. The difference between lead free and lead safe real quick is lead free means there's no lead at all, just like it says, it's free of all lead. If you do have a property, I recommend highly that you make sure that you get the property to be lead free. Then you don't have to deal with this issue anymore. Lead safe means there's actually lead in the property, but it's encapsulated. It's protected in such a way that it's safe for the resident. Once you get the test done, that test is now good for 4 years. But every 4 years, you're going to have to do that test again, and that's going to have to be uploaded to the city of Philadelphia. So if you can get your property lead free, you're much better off. You don't have to worry about this anymore.
Someone's asking in condos, and I assume this apply to rental apartment buildings as well. You can only get lead safe since they don't check the hallways, et cetera. Is this correct? If it's new construction, if it's built after 1978, then no, then it's all going to be lead free. If it's not new construction, then you're likely that may be an issue. Then it might be just lead safe. Okay. Look at that. I think that's it. What are you doing? Do commercial units in mixed use buildings need to be tested? So the residential units will have to be tested. The commercial units do not need to be tested.
Yeah, this is residential only.
No, they're saying because it's mixed use buildings, but you would only have the testing done within the residence unit, not in the commercial space. Presumably, it's okay. They would have no reason to be in the commercial space. It's no different than if they went into a grocery store.
My speaker blipped out. I only heard the end of it. So I was trying to make it sound like I was still going on.
I know what you were doing.
Playing along.
I got it. We're good. And that is the last of the questions. The 3 minutes is spare.
Yeah. Is there any other questions that people have before we end this seminar? Free legal advice. Take advantage. Happy to answer any question you have.
What about an older building that was renovated from the bricks out recently? If you can get it certified as lead free because of said renovations, then you only have to do it once.
Yeah, unfortunately, even though you did a full renovation, the city is now requiring that you still get the lead free certification. In years past, you were good. once you did the renovation, they realized you did a total renovation, that there's no more lead in the property. Now they still want you to do the lead-free certification.
All right, two other questions. One, if you have a commercial space and it's being rented to a daycare center, that's still not residential. I don't know if daycare centers have their own set of rules, though. It's not something I would follow.
I believe they do, but I couldn't swear to that. But I believe that there is a separate law for daycare centers.
Do you need to provide a reason for a denial, including an adverse action notice? Oh,
Yes.
under the new law, yes.
Absolutely.
Can a tenant be responsible for bed bug remediation per the lease agreement?
Not for the first year. So the
Right.
first year is on you. After the first year, the law says that the cost is shared. Nobody knows what that means. The shared means split. No idea. Presumably, but they didn't use the word split. They used the word shared. So
You
the
started out
answer
by
to your
saying,
questions, after the first year, yes, you can
Yes.
share the cost with the tenant.
you start out by saying every unit needs to be lead tested and then said only after 1978. No, every unit needs to be tested. The ones after 1978 will be certified as lead free and then you will not have to do it again. However, every unit needs to be tested to get that lead free. And then if it's lead safe, you have to do it every 4 years. Hope that
Yeah,
clarifies.
just so you know, after March of 1978, they stopped putting lead in paint. So if
That's
your
why.
building was built after March of 1978, it doesn't have lead paint on the property because you couldn't get
Okay.
lead paint
If
unless you had
there's
an
a
old
no-
can sitting around.
or a really bad contractor. If there's a notice period in the lease of renewal addendum or renewal addendum, lease will renew for a term of 1 month unless 60 days notice provided. Can the landlord still give 60 days notice to terminate? Yeah,
If they have good cause to terminate it.
right. So we're going back to good cause. I was curious what this question meant. So no, the question is, you would only have to have good cause. If you want to terminate them, that renewal needs to say 1 year, not one month.
Yeah, that's the problem. If you have a month-to-month lease or a 60-day lease, you need good cause, meaning that the tenants breached the lease agreement to be able to evict them, to be able to and terminate the lease.
And then is an owner required to provide a reason why someone doesn't qualify? Oh, we answered that. Yes, you do. Is selling the property or a tenant paying late rent always considered good cause? Non-payment of rent is going to be different. You're going to file against them for non-payment of rent. That's going to be separate from the just cause part of it. And selling the property, I do believe, is good cause.
So the problem with selling the property is if the new owner is going to live in the property, then that's fine. If the new owner is going to rent it out, then that's not fine. It's a little quirk in the law because what really needs to happen is you need to sell the property, the person buys it, and then the person says, hey, I'm going to live here. And then they're able to terminate the lease because they're going to live in the property. If they're going to continue to rent it out, then no, they can't terminate the lease agreement.
Okay, that's it.
All right. Awesome.
All right.
Thank you.
Jénel, Paul, thank you very much. Great job on fielding all those questions. We covered a lot of ground. And as Paul probably said, I counted 23,000 times. We need another session that could go on for 2 hours. No, but it's the truth. Like some of this stuff, you could really parse it out and go on ad nauseum into all of the nitty gritty of things. I think also too, what was highlighted here and the reason why I posed that question to Paul was city council is constantly doing things. And this is a very front burner thing for them. And they're doing it in a very scattershot kind of a way. So we really need for, Melody from our team, very focused on what's going on in city council with the real estate coalition. And then when we put out a call for action, we need for our members to go ahead and respond because this is kind of like death by 1,000 cuts. And it's not necessarily, sometimes they actually do have good ideas, but sometimes it gets lost in this whole rush to just do all sorts of things that are all over the place. And as Paul was just talking about the good cause bill, we go ahead and we look at it. Essentially what they did was there's no incentive to take a chance on somebody with a month-to-month lease in which they could have the opportunity to build themselves up and go forward. Now it's like, we're just going to get rid of, it's not in the best interest to do that kind of stuff now. So I don't think that that was their intent, but essentially that's what wound up happening through passing that law, because if you're a property owner, you need to protect yourself, and that's part of the reason why we're having a conversation like this today. So sometimes there's some unintended consequences for the legislation that has passed. And as we can see now, there's still a lack of clarity as how some of this stuff is going to be implemented. It's easy to pass the bill, the implementation and where that goes is a whole other thing. So as this proceeds forward, please keep your eyes on your inbox for any communication from GPAR, and perhaps we'll have to have Jénel and Paul back again as this starts to kind of unfold and we get some more clarity as to how this stuff happens in practice. So again, Jénel, Paul, thank you very much. Thank you to all of our members. Great questions. Thanks for engaging and keeping this a lively conversation. Everybody take care. Have a great rest of your Wednesday.
Thank you.
Thanks. Take